Next up on This Week in Law, Camille Fischer from EFF joins us. We're going to discuss DNA privacy, pot privacy, cloud privacy, device privacy, and what we assume will be the end of the monkey selfie case. Matt Curtis, my co-host, is here too. All this and more next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is TWiL, This Week in Law with Denise Howell, Mike Keyes, and Matt Curtis. Episode 420, recorded April 27th, 2018. Privacy Up in Smoke. Hi, folks. I'm Denise Howell, and you're joining us for This Week in Law. We're so glad you're here with us. Hope that you didn't miss us too much. We were out of pocket last week, but we're back and better than ever discussing interesting issues at the intersection of law and technology. We've got a great panel of folks to do that with today. Our guest this week is Camille Fischer. Hi, Camille.
Hi.
Wonderful to have you. Camille is a Frank Stanton Fellow working on EFF's Free Speech and Government Transparency projects. She's an alumna of the Obama White House and the Department of Commerce, where she advocated for civil and human rights and due process protections in connection with law enforcement policies and worked on consumer security and privacy. So it's really great to have you on the show, Camille.
Thank you. I'm happy to be here.
And also here with us is my co-host, Matt Curtis. Hi, Matt.
Hi, how's it going? Very excited to be here and excited to have Camille on, and we've got some fun topics today.
We sure do. And in case you're just joining us for the first time, never met Matt before, Matt is a law student at Notre Dame. How's your third year going?
It's my second year.
Oh, it's your second year.
I wish it was my third year.
Yes, I know. I always assume you're so smart, Matt. I always assume you have more experience. Yes, absolutely. Well, we're glad you're going to pretend well with us today, and we're going to jump into some interesting privacy-related stories to start out the show. So I have been wanting to talk about DNA and other remains for some time. And we do the rundown for the show a little earlier in the week before the late week news breaks. And we were already going to talk about DNA and other remains. And then it came out that, how convenient for us and the show, and how good for law enforcement and people in California that a very nasty character seems to have been apprehended, someone that they've been looking for quite some time in California, who's been known as the East Area Rapist and other things. One of these sort of cold cases that folks had kind of given up on finding this fellow, but a determined DA got together with her team and ran some DNA from the crime scenes against publicly available online genealogy databases. And lo and behold, they have arrested someone that they think has a high probability of being this really bad character. His name is Joseph James D'Angelo, the person who was arrested. And this is all good if they feel like they have the right guy and that this guy is going to finally come to justice. Because certainly, if you've been paying attention to the news about this, you know that the things that this serial rapist and killer has been accused of doing are just awful. So the interesting part for us about this discussion and how it segues into our DNA privacy points is the way in which this suspect was identified and apprehended. As I mentioned to you, the law enforcement officers had what they called abandoned DNA from this particular person. The first step, though, was to take DNA from the crime scenes and then run it through. They have not identified which publicly available DNA database they used. And at this point, I should mention that one of those databases, 23andMe, is a sponsor here at the TWiL network. So they haven't mentioned which one they used, but they took crime scene DNA and they must have created, I mean, I'm speculating here, but what seems the most logical thing to me that they did is create a false profile saying that the crime scene DNA was the DNA of a customer of one of these sites, so that they could create a profile and then attempt to match that DNA up with other customers of these sites. And through that process, again, I'm just speculating here, they found family matches and found someone close enough to the suspect's DNA. They found distant relatives of this person, and he was the right age and lived in the area. And then they found abandoned samples of DNA from him once they had identified him. And those were a match. And they tested it twice. Those are a match to the crime scene DNA, and a close enough match that they're now going to go forward and attempt to prosecute him. So I imagine, Camille, that you're as fascinated by all this as I am. Do you think that the people who are using these databases are aware that, when they do a cheek swab or spit in a test tube and send it in, that this kind of thing could be the result?
I don't think people are aware at all. There's actually a story that EFF had tracked, I think from 2015, that was with the Idaho Police Department. And Idaho Police had done something very similar. They went through Ancestry.com, and they had found a suspect. They had uploaded DNA, found a closely related person, then went through their entire family history to find a suspect. Contacted that suspect, brought him to an interrogation room on a separate crime that they said that he had committed, obtained a cheek swab after hours of interrogation, and made this guy wait for over a month to figure out whether or not he had actually committed a crime. And so under the terms when this person and his family members had signed up for Ancestry.com, there was a statement saying that Ancestry wouldn't share genetic information with anyone. So they actually had no clue that it was shared with law enforcement, and that this could be done.
Right. We remember that guy. We talked about him on the show back in 2015. His name was Michael Usry, if I'm saying his name right, yes. U-S-R-Y. And he got a knock on the door out of the blue. He was told by law enforcement that they were investigating a crime and they wanted to ask him some questions. He ultimately was questioned by the FBI. They swabbed his cheeks so they could do the match. And as you mentioned, he was on pins and needles for some time before the results finally came back negative, that he actually was a match to the crime scene DNA. Phew for him. But you knew at that time that it was just a matter of time before the other shoe dropped. And this may not be the only time that the other shoe has dropped since then, but it's certainly a high profile case, and certainly this person is someone they've been looking for some time. So it's a difficult issue, I think, because there is no human that's not happy if Mr. D'Angelo, he still has to go through the process and be tried and convicted, but they now have a suspect, and a suspect that they feel is likely to be the person who committed these terrible crimes. And if that person is found guilty and is punished, that's an excellent thing. I don't think there's anybody who would take too much issue with that. But it's how we get there that is a bit problematic. And there are some things we should mention just on the legal front. Particularly, this happened in the state of California. And there are a couple of wrinkles to this that people might not be considering, a few actually. So for one, in 2008, California became the first state to authorize familial line testing. Searches can be requested only when law enforcement has a suspect and the DNA is tested against, now these would be government databases containing samples from people arrested or convicted of felonies. And the California Attorney General says that it has run 192 familial searches since 2007 in 108 cases. So that's not quite what we're talking about here, but it's a close cousin to going to, beyond a government database to a public consumer database. And then another interesting wrinkle is that this familial, the collection of DNA to create these government databases that then can be used in familial line testing, that was found by the Supreme Court in 2013 to be not a violation of the Fourth Amendment. That's something that the EFF weighed in on at the time, was not happy with the decision and how it came out, and sort of forecasted that we could find ourselves in situations where people are being pulled over for, a run-of-the-mill traffic violation, for example, and having their DNA collected because they have encountered law enforcement in a misdemeanor or a felony situation. I believe in California, you can only have your DNA collected by law enforcement if you are a felon, or if you're part of a felony investigation, or if you're part of a misdemeanor investigation and have a felony record. Okay, so we have those things going on. And then the other thing going on is what these, and I think this is a real can of worms, what these consumer DNA matching sites tell people that they're doing with the DNA, what they actually do with the DNA, and then what they must do if law enforcement comes to them. And I think that these may be different things. As you pointed out, Camille, I don't think that people know exactly what these sites do with the information that they host. I know that people don't routinely read the terms of service. The terms of service oftentimes do spell out that people will, the companies will comply with valid law enforcement inquiries. But it doesn't seem like that even needed to happen here. If someone creates a profile and sort of games their system by saying, oh, this is my DNA, but in fact it's a suspect's DNA, or a crime DNA collected from a crime scene, then that's certainly a great way to catch a killer. But I don't know that it's a great way to that maybe they're in violation. Are they in violation of the CFAA, perhaps, Camille, by doing this?
Probably not, because law enforcement actually went on and they created the details of exactly what happened with the Sacramento killer haven't been fully released yet. But there have been some people theorizing that law enforcement went on, created a fake profile, uploaded the DNA, and from there actually just used the systems. The way that the platform's set up to match and find family members. And so you could potentially argue that the creation of a fake profile is a CFAA violation. However, I don't see a company suing the government for that. And
the government would likely be immune. But it's an interesting thing just to point out that people have been subject to Computer Fraud and Abuse Act claims because they have created fake profiles on social media. But here we have something slightly different from social media, but I think the principle would be the same. So what do you think will happen, Camille? Do you think that, because in the wake of this, for example, 23andMe has gone to the press and said, in fact, let me quote exactly what they have told people. If I can find it among my open tabs. I think I have it over here. Hold on just a second. We have not received inquiries regarding this case, they said, and broadly speaking, it's our policy to resist any law enforcement inquiries with all legal and practical means at our disposal. Of course, that may be their policy, but their privacy policy also advises people that they as a company may be required to disclose personal data in response to lawful requests by public authorities, et cetera. So, they may, I think it's interesting that from a PR and communication standpoint and a company philosophy standpoint, these companies may feel one way, but they may also have to advise their customers to adequately communicate what may be done with the data. If law enforcement comes to us with a valid warrant, we may try and resist it, but it could still get turned over. So do you see any change happening there?
You can start to see bills that would crop up. So, there might be a legislative solution where states at least advocate for a warrant in every situation. I think after the Maryland case that went up to the Supreme Court, there's a strong argument that to undertake this kind of investigative tactic, that you should actually have a defined suspect and have a warrant. So you may see something like that. However, police have for the last decade created fake profiles on Facebook and gone after gang members and tried to investigate potential drug suspects that way. And so they're kind of just applying, the investigative tactics that they've used to this new DNA social media situation, which is, it's strange. So I think that where you actually see changes is in people's behavior to start to understand that 23andMe, Ancestry, in many ways act like social media. And you should therefore be more cognizant of the data that you give and your privacy settings and kind of understand what's happening. So, the pressure should be on companies to protect their customers' privacy, but there's not much that a company can do when they, as you pointed out, when they have a lawful valid warrant.
Yeah, and again, we should bear in mind that it doesn't seem like a warrant was issued or even sought in this case, because they did not go to the company and say, "Hey, we want you to do the matching for us." They went to the company and used the resources that were available online to anybody that created an account. Matt, any thoughts on this?
Yeah, so just a couple notes on what's in a supply chain of a company like 23andMe or Ancestry.com. I'm not sure which one of them do it, but some of them license their data for massive cancer research projects, which are massively beneficial for the world, and that's part of their business plan. So a lot of them license that data. I think they do it anonymized, or at least they should, to major the MD Andersons, the Mayo Clinics of the world, and they're really pushing the forefront of research. So a lot of that's good. That is another party that can get a subpoena from them. And the second thing is that when you're looking at your DNA, you have this a little bit in social media where you're able to so if, for instance, my brother, I'm going to throw him under the bus here, but if he had committed a crime and my DNA was in a database, they could say that within a percentage likelihood my DNA is like someone else's, and therefore the law enforcement could guess that someone in Matt's family did it, and then they would look, and Mark would have ended up doing something. So, but that's so there is I see the worry there, but I think it comes to what are we giving warrants for? I think that there should be like a warrant requirement that would make tons of sense. And I don't know what the benefit of. I think that it was Ancestry.com who had the open source database. The benefit is there, right? Because having an open source database of DNA, if you don't have names attached to it, there's we see the benefits of open source and software all the time, and to get real research into what's going on with human biology seems like a good thing. The risk is that you can have law enforcement or other people use it for ways that subvert rights. So I think that there's a plus minus here, and I think it would be best to have a warrant requirement.
Okay, so if I'm understanding you correctly, then you would be in favor of legislation that would prevent law enforcement from doing what appears to have happened here, creating a faux profile, masquerading as a regular consumer and using the resources that were available?
I'm saying that if I was running a company and they were asking for my data, that's certainly the policy I would have there. I think that from a consumer standpoint, that's kind of where you need to be. In terms of like a general policy, I think that a world where we have all access to everyone's DNA, that's kind of scary. But that's just a feeling. I don't know if I've thought through the policy enough to really make a policy statement on it.
Right, and that's one of the things the EFF raised in connection with this 2013 Supreme Court decision, which was called Maryland versus King. And there it involved the state of Maryland, which had a very broad law and practice of collecting DNA from all arrestees without a warrant or any individualized suspicion that the DNA would lead to evidence of a crime. It's just to create one of these government DNA databases that then family line testing can be done against without going to a consumer website. In fact, I just wanted to mention that Sandman in IRC says Ars Technica is reporting that the DNA database in question in this Golden State Killer / East Bay rapist case was GED Match, so one of the smaller ones. And also, I guess some of the reporting on this, the New York Times, for example, leads off by saying that Ancestry or maybe it's the Sacramento Bee piece. One of the pieces we have in the rundown for today's show, which I can tell you can find all of these at tagpacker.com/user/thisweekinlaw. We are on episode 420 this week. There is a discussion that sort of assumes that it's that 23andMe and Ancestry have made it hard for you to simply cobble together a fake profile and research in the way that we're assuming happened here. So it would make sense then, if they're right about that GED Match has a different approach, is a smaller site. Maybe they want it to be easier. Maybe they want to build their user base, what have you. Apparently they may have fewer safeguards than what the reporting that I've read speculates that Ancestry and 23andMe have. I haven't used any of these sites enough to be familiar with it in any sort of detail. But it seems to me that what they're positing is maybe these smaller sites are the hazard, that it's easier to sort of game them and pick their data. Of course, they're not going to have as much data either, so maybe that's the trade-off. But what we're getting to, and what the EFF was concerned about when this Supreme Court case came out in 2013, was just how much DNA is out there in how many databases, and particularly this one that was found constitutional in Maryland, where any arrestee is subjected to putting their DNA in a database. And one of the things that EFF pointed out, I think it was Hani Fakhouri, who we've had on the show before, and Jennifer Lynch, who I can't recall if we've had on the show before. They co-authored this piece and said, we may as well just collect it from everyone at birth or from anyone applying for a driver's license. What's the justification for saying, all arrestees is when we're going to collect your DNA? What do you think about that, Camille? Are we moving? Do we need to take steps to prevent that from happening, or is ubiquitous cataloging of everyone's DNA in one place or another just a future that is coming our way?
I mean, yes, we should take steps to prevent it from happening. It's actually kind of terrifying, which is why Jen and that piece may seem a little glib, but it's to point out the fact that this has become so ubiquitous that why not just survey everyone? Why not take DNA at birth? Because if the government isn't going to actually protect and narrow the kind of situation where DNA is taken from suspects, then your movements throughout the world can be tracked and traced. So a lot of times when people think about kind of DNA testing, especially in the law enforcement context, they think of like blood left behind at a crime scene or other, large quantities of genetic material left behind at a crime scene. But there's actually now partial DNA testing that can be tested from fingerprints left behind and kind of like DNA factors that you pick up. And I may have the terms wrong and the science wrong. This isn't something that I work on every day, but it's actually becoming far easier for law enforcement to test DNA with much smaller samples, to test DNA at low-level crimes, so like petty property damage or petty property theft cases, and especially with the rapid DNA machines, law enforcement can now test in the field. And so it is kind of becoming this situation where if so many people's DNA is collected and it's becoming easier and easier for law enforcement to test, then we are like approaching a mass surveillance situation. Right.
So a couple of areas to think about from a policy standpoint from this discussion. Do we want such ubiquitous access to people's DNA to put in these government databases? The Supreme Court has said, their ability to do that is not unlimited, but has certainly validated this very broad law in Maryland, where if you've come into contact, if you've been arrested, contact with law enforcement in the context of an arrest, they've got your DNA and it's going in a database. Secondly, do we want law enforcement to be able to masquerade as someone who's not law enforcement, to be able to exploit the availability of these non-government databases for DNA? And then thirdly, and I think this is really interesting, the way they found, they did the matching for this Golden State Killer fellow, is they used, once they had narrowed it down to, it could be him, because he was a person that had distant relatives that matched the crime scene DNA, and he was the right age and he lived in the right area. Then they obtained what the district attorney has called abandoned DNA samples from Mr. D'Angelo, the suspect they were looking at. So that means, what did they do? They went through his trash and found DNA, or other, they went to his barber and collected clippings. We don't know what they did, but somehow they got abandoned DNA samples from Mr. D'Angelo. And the DA has said on that topic, you leave your DNA in a place that is a public domain. And so she feels, fine about collecting that DNA. And I think from a legal standpoint, she's probably right. That's how the state of things are now. So point 3 for our policy discussion, do we want this? Is this the world we want to live in? Is it okay that the DNA that you leave around in the world is quote unquote abandoned? How do you feel about that, Camille?
It's actually really interesting. I'm blanking on the name of the case, but there's the Supreme Court case where once you put your trash on the curb, you've therefore abandoned it and you lose your expectation of privacy. And it's something that we're constantly coming up against in today's modern world. That's been an argument for a while for if you delete a file off your computer, you've therefore thrown it out the same way you would trash on the curb, and law enforcement should have access to it. And you've seen that theory be debunked. And it's terrifying with DNA because it is much closer to trash. From DNA is not trash, but the kind of like fact pattern when you think of like physical, tangible property or evidence is closer to the like trash on the curb case. So while I think police have like a very solid legal theory to kind of test abandoned DNA, from a policy perspective, it's a bit terrifying. And I think it's something that, hopefully we'll start seeing at the state level pop up, and state legislatures will start to kind of acknowledge the privacy risks and put some needed restraints on police DNA testing.
Right. And it's not just the police who might want access to quote unquote abandoned DNA. Someone might want your DNA for commercial purposes if you are a celebrity, for example. Matt, were you going to say something?
Yeah. So my question is when we're drawing the line between, everyone's pretty much fingerprints are in some sort of database, or at least, I think that we did database or like fingerprinted driver's license. I can't remember those too long ago. But so what is the line that we're drawing between fingerprints and DNA? And is it like a really like consistent line? Because let's say that, for fingerprinting people at crimes, and that's 80% effective of determining who is who. And DNA is 99% effective, and we're actually getting better information on who the real suspect is. I don't know if those numbers are true, but like if that's the case, like is it a good idea to draw the line just because we've been fingerprinting in the past and we haven't been having your DNA in the past? It seems like we'd be blocking the better option on principle and not really thinking through the logical implications. I'm not sure if those numbers are real or not, but like is there a broader concern here than that?
What do you think about that, Camille?
I'm not entirely sure.
Okay.
That's sorry, I was actually checking email.
That's okay. Matt was wondering why we don't have this sort of visceral reaction to arrestees being fingerprinted as we would to arrestees having their DNA collected. That we're and I think what you're saying, Matt, is we're used to the fingerprinting process. It's something we've all grown up with, and we're not collecting.
And at least we know it's less accurate than DNA. So at least with DNA, you're getting more accurate. So hopefully you're getting the right suspect, which is still an invasion of privacy, but like at least you got the right person, which seems like a big deal.
But even with fingerprints, we're not putting people in universal fingerprint databases at birth. At some point along the way, maybe we are. Certainly if they get arrested, I forget if I had to give a fingerprint for a driver's license. I don't think I did the last time I went in and renewed.
Okay. Maybe it's just Michigan.
Oh, really? They do it in Michigan.
I know I got fingerprinted at some point, and it wasn't because I was arrested. So it was something.
That's good to know.
Yes.
Yes, I think this abandoned DNA thing is something very interesting that I'm sure we'll come back to. There's another piece in our discussion points that I just wanted to highlight because, Matt, we're going to put everything on the blockchain, and maybe this piece here where, let's see what the author's name is. It's Dr. Alex Schumacher, who is the co-founder of a blockchain-enabled genomic data hub called Shivom, SHIVOM. And his argument is that the information in these consumer DNA databases would be far more secure if all the data were on the blockchain. What do you think, Matt?
So if the blockchain is decentralized the way that some of our Bitcoin is, that's probably true. But like blockchain is a technology that could be centralized as well. It's just a method of recording your data, so it could be even more insecure too. So I'm just not sure that it seems like the issue is that you had an open sourced DNA profile and not that the security protocols. I'm pretty sure that there were security protocols that could have been better than what they were using. But
I guess
once again, I'm just a skeptic.
Yes, I guess point 4 for our policy / lawmaker / look for legislation possibly in this area discussion would be state and possibly federal laws regulating even more how these databases of DNA information that are being collected and maintained by private parties, how they're secured. Do you have any handle, Camille, on whether these companies are subject to any heightened scrutiny or security measures than say a regular health data site?
So I believe that there is a kind of federal genomic law. I don't remember exactly what it says, but I think that there either is a law or there have been proposals to kind of heighten the privacy interests around your DNA sequencing code. However, one of the largest problems in this kind of healthcare space is that the FDA regulates what we think of as traditional medical providers. So the FDA will regulate drugs. It will regulate a defibrillator. It will regulate a pacemaker. But they don't regulate things like your Fitbit, which is, inherently tied up within your health data, but is kind of a consumer device that the FDA doesn't feel that they have the appropriate oversight over. And the same thing is happening with these genetic testing websites like 23andMe and Ancestry, and even some of the testing sites that are trying to analyze your kind of gut flora to figure out what you are potentially allergic to. A lot of them, they don't have the FTC and FDA don't necessarily have the appropriate levers. So if the company's making a false or deceptive claim, the FTC can go in. If Congress actually expands FDA's authority, they may be able to work in this space. But it is in some ways like the Wild Wild West.
Right. Yeah, I'm guessing that for the time being, states and the federal government are lumping DNA collection sites and services in with other people who have your personal information and are regulating them under the laws that exist to regulate those things. But we do have, I think the law you might have been thinking of is mentioned in the piece I was just talking about by the blockchain-enabled genomic data hub author, Alex Schumacher. The law is called GINA. It is the Genetic Information and Non-Discrimination Act. It's a federal law enacted in 2008. It prohibits health insurers and employers from requiring or using genomic data to make decisions. However, what Dr. Schumacher points out is that the law does not preclude, say, a life insurance provider from asking for your DNA information when that data exists. All it precludes them from doing is using that data to make a decision. So, that's cutting it fairly fine, but it seems to be a loophole they could jump right through to get that information and look at it and then say, oh, no, we didn't use that to make our decision to deny you coverage. No, not at all. So something to just bear in mind there. One other story that I put in this part of our discussion doesn't have to do with DNA, but does have to do with fingerprints. And here, we've talked before about whether you can be required to provide your biometric data to unlock a device, and tension in the law about that. Well, there's no tension in the law about that if you are deceased. And we had an example of that in Florida, I think just this week, where a couple of Florida police detectives were investigating a drug crime where they hoped to get access to a deceased person's phone to go ahead and continue their investigation. And a gentleman named Linus Phillip was killed after they pulled him over. He was killed when the two officers tried to arrest him after smelling marijuana in the car. He attempted to drive away. He was fired at. He crashed his car, and then he was pronounced dead. So there in the funeral home, the police officers showed up. They did not have a warrant. They just told the funeral home, hey, we are going to use this corpse's fingerprints to attempt to unlock this phone. And they tried, but they failed. So apparently dead biometrics don't work as well as living ones. Who knows? Maybe maybe his phone was not set up for biometric access, but they did make that effort. And the deceased's fiance said that she felt very disrespected by this and violated. But the detectives correctly point out they don't need a warrant because constitutional protections against searches don't apply to the deceased. Any thoughts about this, Camille?
Yes. I haven't dug significantly into the case law saying that constitutional protections don't apply to the deceased. Mm-hmm. However, when you think about it from an email context, police to get the entire contents of someone's Gmail after they've died, police still would need to obtain a warrant under the Stored Communications Act. Mm-hmm. And I mean, essentially, even though the police were using a fingerprint to get into a phone, they're essentially looking for the same type of information. So the data that's stored on this person's phone. And so the fact that they would so unethically argue that they can just take a dead man's finger and get into his digital information, whereas they would actually have to get a warrant and serve that warrant on a internet communication service provider is upsetting. And I think the fiance has every right to kind of call out the unethical treatment that the police used on her now deceased fiance. And I think it does raise a lot of questions of whether the police would do this if this was a higher income and non-minority person.
Yeah, and I think just sort of shifting the discussion, we were talking about abandoned DNA. You know, you've abandoned all your DNA once you're deceased. Does that mean that it's fair game, both for law enforcement and for third parties who may be pursuing some commercial interest in your DNA? So I think, you know, point number 5 for our policy discussion of is this the world we want to live in and should lawmakers be paying attention is, you know, what sort of protections do we want to give that don't now exist to someone's remains, whether it's trying to open a phone or, you know, cutting fingernails so that perhaps their DNA can be leveraged for some purpose. Matt, any thoughts?
I don't really have a clear conception on how we should treat dead people, but it seems like avoiding them seems like they weird me out. That's why I do tech law. So I'm going to leave it to you guys.
All right, good. To be continued. Hey, we're sitting here in episode 420, which would have been recorded on April 20th if we had not taken last week off. Apologies for not making that serendipitous reality come to life. But on episode 420, you know, as long as we're talking about DNA privacy, I thought we should talk about weed privacy, especially here in California, where as of the 1st of this year, recreational marijuana is now legal for those 21 and over. And I do think that there is a tech law tie-in here because a lot of people will locate their legal recreational marijuana using tools that are technological, whether it's an app or some other means. And their information when they purchase legal recreational marijuana, oftentimes, even if they're not, you know, doing some sort of Uber for pot to locate and or have their weed delivered, if they're just walking into a dispensary, there are a couple of data points that the dispensaries are required to collect. They're required to validate that you're over 21, and they have some monitoring they need to do. I think the state can only allow them to sell a certain amount of marijuana to a single person in one day, so they have to log how much you're purchasing as well. So on the one hand, the dispensaries are in this situation where they have to collect data. On the other hand, I'm sure the dispensaries and the people frequenting them are anxious not to have a database that is available to the federal government that still considers recreational marijuana use, despite what these pesky states are saying about it, a federal crime. So if the federal government got aggressive and decided to, hey, where can we start prosecuting people who are recreationally using marijuana in violation of federal law, we could easily start with the databases that these dispensaries are keeping. So definitely some privacy considerations there, both in how you're finding and having your marijuana delivered to you, and even if you've not used a technological means for that, the databases that are being kept by the dispensaries, however you're getting there or accessing them. Camille, any thoughts?
Yeah, you hit the nail exactly on the head. The thing that terrifies me the most is the fact that while it may be legal in California, marijuana is not yet legal at the federal level. Even though Chuck Schumer and Cory Booker have proposed legislation. And so it would be fairly easy for the FBI to come in and request databases of all purchasers. And not only do the databases have purchasers for every single day, my understanding is the way that a lot of the dispensaries are doing it, they're actually tracking people over time. So the FBI could request someone who has bought over a certain amount since marijuana has become legal in California. And so they could go after kind of like, I don't know, the big game purchasers. I'm not entirely sure why California decided to have all of these reporting requirements. It is quite a large break from the statute in Colorado, where it is far less regulated. I think in Colorado, you have to use cash purchases. This isn't an area of the law that I've dug in detail into, especially since I used to come from the federal government. So it would have messed up my clearances if I had Google searched too much. But no, I mean, it's from a kind of like human rights and how does state law interact with interact with federal law, and so like 10th Amendment constitutional concerns. I'm a little terrified.
Yeah, absolutely. I have to back you up for a second. When you go to get a security clearance in Washington, your Google searches are fair game?
No, I don't think
not as far as you know.
Not as far as I know, but I mean, I think it's good to be paranoid.
I think it depends on what level of clearance you're going for.
Yes, so
I think if you're getting higher level clearance, it's definitely fair game.
Yeah.
Yes, indeed. There is a law pending in California, a proposed law pending that is Assembly Bill 2402 that would ban retail marijuana shops from selling customer data to third-party vendors without the customer's consent. But that doesn't really address what we're talking about here. Just having the data in a database is problematic for the people who are going to be using these services. And that could be the dispensary's database or the database of any of the tools that they may be using. There are a couple of apps out there that will help you locate your legal recreational marijuana. And obviously they're collecting data too. Do you expect California maybe to enact something supplemental, or do you think that they'll be satisfied and think people's rights are sufficiently protected if this bill that bans selling for third-party use passes?
So actually, I think what's really interesting about California law is the ballot measures and the ballot initiatives. So I feel like if enough recreational users actually kind of band together and they pinpoint problems that they see in the system, and they get a ballot initiative to pass, I think that's actually where you are probably more likely to see change in California, is from the residents and not necessarily from the legislature. The sharing with third-party sources actually, even though it wouldn't stop law enforcement, the current practice of sharing with third-party sources actually makes it easier for law enforcement to track who is purchasing recreational marijuana. You could potentially see the dispensary sharing with Facebook using this as a part of the ad system, and then FBI looking at people who have recently traveled to California, doing some kind of request for ad preferences, finding someone whose ad preferences are based on the purchase of marijuana in California, and then prosecuting them in another state. That would be like very convoluted, but it's still, it creates a new data point and a new point of entry for law enforcement to get people's information.
Right. We need to insert our first MCLE passphrase into this episode of This Week in Law, and with a hat tip to Eric Johnson at Recode, who put this in his headline for the piece we have in our rundown. Our first passphrase is going to be Uber for pot. He wrote, marijuana is legal in California now. Will an Uber for pot gold rush follow? And it may. So that will be our first passphrase. We put these in the show in case you are a lawyer or other professional who likes to watch or listen to our show for professional credit in your field. If you are a lawyer, you can head on over to wiki.twit.tv, find our This Week in Law page there. And we have a chart, if you're in the United States, to various jurisdictions and what forms you may need to consult and use and whether that's even available in your jurisdiction to the best of our knowledge. So go check that out. It may help you if you are a U.S. lawyer. And we'll put another passphrase in somewhere later in the show. We put these in just so that you can demonstrate to anyone who needs you to demonstrate that you actually watched or listened to the show. Let's see. One more privacy related story or just a mention here. I haven't seen it yet. It's not popping up as a browser-based update, but maybe I just haven't updated the app on my phone. But I understand that Gmail has done a big redesign, and I'm assuming that all I need to do is update the app and it'll be there. I haven't seen it yet, as I mentioned. However, it looks like lots of changes are in the works to how Gmail works, and also that something very interesting called, what is it called? Confidential. Help me out here, Camille. What are we discussing here? There's a confidential mode. Confidential mode is what it's called. It lets you have an expiration date for email, and it is supposed to prevent recipients from forwarding, copying, or printing your email. Jonathan Annett, one of our listeners, points out that it's sort of funny to think that it might not be able to be printed, that print screen is actually a thing. And so whatever Google does isn't going to cut that off. But he tossed into the mix this notion of, okay, so Gmail is telling folks that if you've received an email in confidential mode with an expiration date, et cetera, that it's set acceptable parameters for your access to that information. And what he was interested in is, so if you violate that, if you do a print screen on it, have you violated the Computer Fraud and Abuse Act? What do you think, Camille?
I think probably not, but you could potentially see an interesting case come up. So in the Computer Fraud and Abuse Act, there are a few different points that it lays out, but the overall scheme is prosecuting anyone who knowingly accesses and then uses data without authorization. When you receive email, you have permission to access it. That's the entire point. And I mean, further, it would be really hard for someone to knowingly differentiate between what is this confidential mode email and what is just like standard email that they receive in their inbox. And when you look at use, it's actually really interesting. So if you're receiving, I don't know, quote requests for a construction project that you're doing on your house, if the quote you receive is in confidential mode because the construction company wants to say it's trade secrets, you may want to screenshot that so you can save it on your hard drive and have it in a file for what you're using for tax purposes at your year-end write-off. So it actually makes like very little sense on a user standpoint to go after people who have screenshot an email. However, I mean, there may be some like fringe case where it is an employee screenshot something, steals, I don't know, employer secrets. You could see this probably popping up in like a smaller jurisdiction. But like 95% of the time, I don't think that there would be any CFAA violation.
Right. Matt, what do you think about like spoliation of evidence concerns? Do you think that from a litigation discovery, law enforcement evidence kind of situation, having emails that self-destruct is problematic at all?
Yeah, so I think you'd have to have protocols in place so that, if spoliation only kicks in, I only understand this on a low level, but I think spoliation kicks in when you actually when you're on notice that an issue is likely to be brought to trial or to court or in some proceeding. So you would just need to make sure that you could turn that confidential mode off and retain that data for spoilage. On the question of the CFAA, though, I think the Seventh Circuit's case law would lead you to believe that if you enter in a contract that says that you can have this information for X number of time and you use it for X plus 1, it would actually, I think Easterbrook wrote the opinion that said, the X plus 1 is you knew about it. That was the that was the term of the contract, and your contract ended, and you continued to use the information. That's a violation of the CFAA. I don't think that's a good ruling. But I think that's the case law. I think the Ninth Circuit and the Second Circuit have good case law, but I think it's the Seventh Circuit that doesn't have good case law. Right.
Is there intersection between this, Camille, and the Electronic Communications Privacy Act?
I mean, not entirely. Well, actually, I haven't thought through a fact pattern. So maybe I'd actually have to kind of like sit down and think it through. Come back to me on that.
I will, yeah, because I wonder if there's a difference between how this plays out, this confidential mode, between what the users are able to access and what Google is able to access. Does putting it in confidential mode mean that it's no longer something in Google's databases and therefore no longer subject to subpoena? I don't know how they're doing that, but I think it's interesting.
It's actually, I almost wonder if it would stay in the sender's file and stay in their records and then only be deleted for the recipient. Because that would raise a really interesting subpoena and evidentiary concern.
Right.
All right. I wish there was more details.
Yeah. So we'll think about that one. And Loquacious One tells me there's a way to switch to the new Gmail in options. So I may have to do that and kick the tires. Thank you, Loquacious One in IRC.
And it is fantastic. I love it.
Sorry?
I love the new Gmail. That's just...
Okay.
Yeah.
Good. I liked it when they... whatever update they did several years back where you could prioritize your inbox. That's been very useful.
Yep.
Definitely helps me keep on top of things. All right. We're going to move on from these privacy-related stories that we have been discussing to discuss some privacy-related legislation and policy. So we've talked in the last couple of months a lot about the Cloud Act. We've talked about the Microsoft case, U.S. versus Microsoft case, where they were storing data in Ireland. And there was actually Supreme Court briefing and oral argument on this. I don't believe we've actually had word from the Supreme Court as to whether it's going to punt on the case in light of the Cloud Act. Fill me in if you know about that, Camille. But the Cloud Act did come along and sort of moot the issues in that case. And tell us more, Camille. You've been looking at this act and writing about it for EFF.
So as you correctly pointed out, it's not officially, no, it has been mooted by the Supreme Court. Yes, that happened maybe last
Supreme
week.
Court has said we're done. We're not going to decide this case now.
Yes, so they sent it back down to the lower court for the lower court to officially vacate. I think that happened maybe last week, maybe 2 weeks ago. It was a very small news cycle day. So as you pointed out, I've been working on the Cloud Act since it was first introduced by Senator Hatch in February. It became law on March 23rd. That's when President Trump signed it into law. However, it went through a very strange process for actual policy legislation. So the Cloud Act was attached to the Omnibus Funding Bill. That's the bill that enables the government to stay in operation because it funds important government missions. Typically, the omnibus is just a money bill. You don't actually see policy in it. However, the Cloud Act was attached as kind of the final provision. And it was attached that way because of significant pressure from the companies, but also significant pressure from the U.S. law enforcement community and from the British law enforcement community. So what the Cloud Act essentially does, it's separated into two parts. The first part of it, it allows U.S. law enforcement to serve U.S. legal process anywhere. It doesn't matter where data is stored. As long as there's a significant connection to the U.S., it doesn't actually matter the nationality of the company or potentially of the person, of the target that U.S. law enforcement is making a request of. So you could see if there are, in a case where U.S. suspects are using Telegram, which is like a German company, the first part of the Cloud Act would actually allow U.S. police to serve a warrant in Germany, which pop-ups came up on my computer, which goes against the traditional MLAT process that the U.S. has engaged in for decades now, and which was agreed upon by an international body in this thing called the Budapest Convention. The second part of the act, which is what gets the most attention because it creates a brand new regime that also circumvents the MLAT process. It allows the Attorney General to designate certain foreign countries as countries that apply to certain standards within the Act. So there's a few standards for free speech and due process. They're not as high as our constitutional standards. But it allows the Attorney General to designate these countries, and then these countries can use their own domestic law enforcement process to come into the U.S. and serve their domestic version of a warrant or the domestic version of a subpoena and get information that's stored in the U.S. from U.S. companies, by U.S. companies, so long as the foreign nation does not directly target a U.S. person or someone living here. However, it doesn't, you can obviously see U.S. people and people living here, their information being kind of collected from the periphery, because especially in email and like online communications, you see like the global free flow of information. There are many people who in the U.S. who talk to non-U.S. persons. You can see that information easily being collected by foreign law enforcement.
Right. So have you thought through the fact patterns in the wake of the Cloud Act? What are some problematic things that we might see happen?
Yeah. So the first country that will probably be certified under the Cloud Act will be the United Kingdom. Ellen Nakashima of the Washington Post, she actually broke a story in 2016 about the U.S. and the UK engaging in an international agreement between the two countries that would allow them to serve the domestic process in each other's country. And so the Cloud Act is the legislation that would kind of like enable this. So the first country that's going to be certified is the UK. You could easily, because it's the UK and we share a common language, and also many of our citizens share like a lineage from Britain. It's fairly easy to come up with a fact pattern where a US person is engaging in business with a British person. So let's say in New York, they're using Slack to kind of talk about their business and go back and kind of like, to talk about the business. And the British and London police decide to serve a warrant on Slack because they suspect that the British person is engaged in financial crimes. They get all of that person's Slack messages, and included in that would be all of the U.S. person's messages. From there, British police could determine whether or not the U.S. person is also engaged in financial crimes, and could share that information back with U.S. law enforcement. And U.S. law enforcement could prosecute based on that information, even though it wasn't collected under a warrant.
Fascinating. Matt, do you have any questions?
Yeah, a couple questions on that fact pattern. One is, could they have done that already if the data was already in the UK? So does this treaty only have effect in that fact pattern if the treaty was only being stored in the US? In the second, is this so it allows the administration, to the executive, to essentially make these agreements with other countries. I'm not too familiar with treaty law, but is this a treaty, and therefore does it require 2/3 majority?
So, to your first question, if the data was already stored in the United Kingdom, British police would have been freely able to access it, and they would be able to share with U.S. law enforcement, and that could lead to a prosecution. We weren't really seeing that before the Cloud Act, simply because there isn't very much data stored in the UK. There's actually a lot of US companies have servers in Ireland, but because of the break between England and Ireland and the break between England and the EU, Irish data centers actually have heightened levels of privacy than data servers in the UK would have. And so we really just weren't seeing that fact pattern. And that's part of the reason why the UK had so heavily lobbied for the Cloud Act, is because their law enforcement weren't able to easily access information to prosecute crimes in England. And this is an executive agreement. It's not a treaty. So the executive is free to enter into an agreement. Within the Cloud Act, there is a process by which Congress can then oppose an agreement. It's not as robust as the treaty process. So the Attorney General has to certify that a country is in good standing with the requirements. And after the Attorney General certifies, Congress has 90 days to object. It's actually very similar to the Congressional Review Act, where if an executive agency creates a regulation, then Congress within 90 congressional days can actually oppose and submit legislation to stop an executive agency regulation. So they could do something similar in this case. It's going to be very hard for Congress to get enough people on board to submit legislation, get it through committee, have it pass the House, have it pass the Senate, and oppose an agreement.
Great, thank you.
All right. Anything else you want to let our listeners know about the Cloud Act? Anything that they should be aware of, other than the fact that their data may wind up in the hands of foreign investigative agencies in the way that you've described, despite the fact that they reside in the U.S. and there has been no warrant for the data? Anything else that folks should know and possibly want to get in touch with their lawmakers about?
Yeah, so there is so many things.
Yes.
But there are similar proposals coming out of the EU right now. The EU process is a bit slower, but there have been proposals for both, I forget the right terms, but there have been proposals to enact something similar to the Cloud Act that would allow EU law enforcement to serve process directly on a company, no matter where the data is stored, no matter the nationality of the company. And so this kind of creates a race to the bottom approach, where countries have stopped abiding by international treaty since the U.S. has decided that it is no longer beholden to the internationally agreed upon process. And we're seeing it right now to the EU, but it's fair to assume that we'll see it out of China, that we'll see it out of countries in the Pacific, and see it out of South America. So a few years ago, you may remember that the Facebook vice president in Brazil was jailed for not turning over WhatsApp information. We're going to start seeing those type of scenarios escalate. And so it's creating privacy problems for people's data, no matter their nationality. And it will end up creating like huge economic risks for U.S. companies.
Okay, one other thing I want to discuss on the law and policy front before we have to let Camille go is this issue that comes up over and over again. We've discussed many times on the show, the law enforcement going dark issue and the question of whether tech companies can be compelled to build backdoors into operating systems for mobile devices and other devices. We have discussed, I think, how Ray Ozzie had posited a solution that's been written about in numerous places for accessing encrypted data on devices that supposedly still keeps the device secure, satisfying the concerns of both law enforcement who need to do their jobs and don't like it when people can, quote unquote, go dark. And also the concerns of, the vast majority of law-abiding users who don't like the fact that their operating system may not be secure, and that's obviously a bad thing, and that their data might also be available accordingly. So Matthew Green, who teaches cryptography at Johns Hopkins, has written a Twitter thread where he goes through in great detail and unpacks and critiques the Ray Ozzie proposal. Back in the early days of blogging, we would have called this a fisking. Now I suppose it takes place in Twitter threads. And Kevin Bankston, your colleague at EFF, somewhere in the comments to this says, please make this a blog post. Make it something that we can hand to people on the Hill so they understand. So hopefully that can be done. But I'm curious to get your thoughts on this, Camille. I take it you're in agreement with Matthew that Ray Ozzie's proposal was a bit too good to be true?
I am. So anyone who hasn't read Matthew Green yet, you should. He has his own blog where he did summarize this in a 2-page blog post.
Good.
He's absolutely fantastic. So if you want to get up to speed on cryptography, listen to Matthew Green. I think so the top line thing with this Wired piece is that it's kind of important to point out this isn't actually a proposal. It's not fully fleshed out. It's the framework for something that he wants to introduce more conversations around and get more people to be engaged, and from there potentially create a proposal or really just create a dialogue. So it's a framework for dialogue more than it is an actual proposal to kind of balance the competing interests of encryption. Mm-hmm. And what he's proposed isn't what he's laid out as a framework isn't entirely new. At its essence, it is still a type of key escrow system. I think the new point of it is that it will allow Apple to completely brick a phone once law enforcement has requested the special law enforcement like PIN or passcode. And so that is something new. But it does still rely on these key escrow proposals that have been circulating the past few decades, really, and it relies on security within the phone's operating system. So for Apple, that would be the secure enclave, and we've seen a bunch of people try to like push and test at that, and there are still significant problems, and there are things that, if he wants to continue pushing this framework forward, have to be worked out. One of the largest ones is when you give companies all of this kind of like power. And so really you're creating a honeypot. So you are ensuring that companies will be able to access devices again. Apple got rid of their ability to access devices as a security measure. So it's kind of introducing companies back into the phone. And then it's relying on their existing security mechanisms. But this reliance then makes the existing security mechanisms a target. And we've already seen that the secure enclave isn't infallible, and that key signing isn't infallible. And so there are exploits that have already been used that will just ramp up if this becomes a mandate. So another point is that it relies on this kind of like secure enclave that's already on the phone. However, there are companies that have already proposed mechanisms to bypass this type of security. So if you've seen the articles about Grayshift and about Celebrite, they say that they can kind of like bypass the password guessing function of the secure enclave and allow law enforcement into the phone. A very similar exploit could be done if you require Apple to store a separate passcode within that secure enclave. And then it ends up creating a very large equity problem. So the kind of new point of Ray Ozzy's proposal is this self-destruct function. So once law enforcement requests access to a phone, it's no longer able to be used. It's receiving no new information. But cell phones cost upwards of $1,000 to actually have every suspect, to have law enforcement be able to get into the phone, brick it, and then require them to buy a new one is crazy. So I think
is it a taking?
It is. It's a conversion.
Yeah.
Rihanna Pfefferkorn, I'm probably pronouncing her name wrong, who is a researcher at Stanford. She kind of correctly pointed out yesterday on Twitter that it's actually going to lead to situations where law enforcement kind of compels people to decrypt the phones themselves. So it's like, give me your fingerprint or give me your passcode, or you're going to be out $1,000 because we're going to brick your phone. And that's just a huge imbalance of power that's already within our system, and it creates an incentive to further rely on that imbalance.
All right. Well, thank you for walking us through that. Matt, anything you want to add?
I just like the takings argument. I think we should run with that one. I think that would be a really interesting analysis of, what was originally the takings clause at all is about, taking your property in order to, build a road, build a highway, anything like that. And so I think that, if it's forcing you to take your $1,000 property, I think that's a really interesting way to bring that clause into the 21st century. Yeah.
There may be some sort of required compensation for all this, but again, we're far away from there being a solution that actually privacy advocates and law enforcement agree is a good solution. So it's good that these discussions are taking place, but I feel like we've got miles to go still. You agree, Camille?
Miles to go.
Miles to go.
So it's not new for government and for people to be thinking this through. I think that there's been an over-reliance on the kind of like the rhetorical trick of saying that engineers just aren't interested in finding a solution that allows law enforcement access, but also enables security for all consumer devices. And I think that's simply not true. Engineers at their heart like to solve problems, and you've given them a big problem, and people just haven't been able to solve it yet. And so Ray Ozzy's proposal does kind of create a new talking point, and it's a new framework to start analyzing and looking things through. But I think the thing I want to stress the most is that people shouldn't rely on this as an actual proposal, and I really hope law enforcement isn't relying on it as a fully fleshed out proposal.
Right. Well, good. Thank you so much. We're not going to conclude the show just yet, but we're going to let Camille go and continue her good work with EFF. We can't thank you enough for joining us here today on This Week in Law, Camille. It's been a great pleasure speaking with you and getting to know you a bit better. Is there anything going on with your work or at EFF that you want to let our listeners know about before you sign off for the day?
Yeah, so actually next week, EFF is hosting a panel in DC. It will happen actually in Congress. You can go to our website to check it out on encryption. It's called Bring in the Nerds. It will be one of EFF's staff technologists, plus Susan Landau, I'm butchering her name too, who is an amazing cryptographer, Matt Blaze, who is the original cryptographer who found the vulnerability within the government's Clipper chip in the 1990s. So he's like fantastic. And Apple security engineer who created the secure enclave, or at least works on the secure enclave. And so it will be a panel of all of these like fantastic technologists to describe what actually happens on your phone and like how encryption works, which I think policymakers need. And it's open to the public. All you have to do is pre-register so that Capitol Security knows who's coming into the Capitol. But you should definitely check it out.
Oh, that's fantastic. And will it be recorded? Will it be on C-SPAN or elsewhere?
It won't be recorded. There were concerns from some of the panelists with it being recorded, but it is free and open to the public because it's at Congress. Right. So yeah, so you should go.
So presumably, for those of us who can't be there, there will be a hashtag, and we'll be able to find out about it that way. So yeah, that's fascinating. Are you going, Camille?
I'm not. Two of our attorneys who more closely work on encryption, they'll be attending for the week to also talk with policymakers as well as our staff technologist. But I have to be here. A few of my cases are popping here, so.
Yeah. Things don't go on hold. Well, we're so glad that you've put things on hold to join us today. We really, really appreciate it. It's been great.
Thank you for having me. It's been a lot of fun talking to you guys.
All right. Take care. Until the next time.
Bye.
Thank you.
Okay, so we're going to soldier on without Camille. We have a couple of other items to end out the show with. Newsworthy events in courts that we thought we should let you know about. The first one has to do with copyright. Folks, we thought we had said goodbye to Naruto, but we were just so wrong. Actually, we were not so wrong, because we said when we reported that the case involving the monkey selfie and PETA's action against a photographer and a third-party publisher that published the photographer's works that included a much-loved photo of a much-loved macaque that took a photograph of himself. There is some debate as to which monkey actually took the photo. We're not going to go into the weeds on all that. But what this case that we have much loved settled. And we told you at the time that as part of the settlement, the parties had asked the Court of Appeals to vacate the decision of the trial court, which found against PETA. And we thought that the Ninth Circuit might have some problems with that. And it turns out that we were correct. The Ninth Circuit went so far as not just didn't vacate the lower court decision, but affirmatively affirmed it, said the lower court was correct, came in and issued its own decision in the case despite the parties' settlement, and made it quite clear that just how unhappy it was with PETA on a number of fronts. the judges had some disagreements along the way. There was a panel of 3 judges, Judge Carlos B., Judge Randy Smith, and Judge Eduardo Robreno. And they didn't agree on everything, but they did agree that this whole concept of making PETA Naruto's next friend and therefore giving PETA standing to sue was problematic. And so the whole next friend concept is something that the judges didn't like and held in general that animals cannot be represented by next friends. What else? The court also wanted to make it quite clear that animals can't hold copyrights. So despite the fact the parties settled and that PETA wanted this lower court case to go away so that there wouldn't be bad precedent against it on the books, it did not get its way. And the Ninth Circuit decided to weigh in regardless of the settlement. Matt, what do you think about all this?
Yeah, so I think that PETA should just appeal this, and I'm willing to throw in a few dollars that a law student has, because this has been way too much fun. This has been going on since before I joined TWiL, so I don't know what to do without it. But
Yes.
The other thing is that the disagreement between the concurrence and the majority opinion is really interesting, because what the majority opinion said was that you can't have standing as a monkey or as a next to friend of monkey if it's not authorized within the statute. So that is that limits it to the Copyright Act, which the Copyright Act does not specifically authorize monkeys or any other non-humans to get copyright. But the dissent wanted the rule to be that, look, you're an animal, you can't get you don't have standing, period, end of story, full stop. And so I think it would be great for that to go up to the Supreme Court and to really fight that one out. I know that PETA would be arguing that animals can have it, and but I think that's a so that was kind of a fun, and I think the dissent or the concurrence was like 15 pages. So
Yeah.
they really went after this one, and there's the visceral words fought over the standing of Naruto, who may not even see himself as Naruto or herself. We don't even know.
That's right.
So I just think this is great fun. That's what I have for this.
Yes.
But yeah, I think the standing issue. Whether you're an originalist or not, I think it's very hard to argue that the founding generation thought of animals as having rights of people, especially since we had other people who didn't have the rights of people. So it's just a bizarre case, but it's had a lot of legs, and it's been fun.
Yeah, it has, and I think has broader ramifications, as we've brought up numerous times on the show, of whether non-animal intelligences might be given similar consideration by entities that decide to represent their rights. I think I'll give Kathy Gellis the last word on this for this episode. At any rate, I can't imagine that it won't come up again on our show because, as you say, Matt, it's one of our mainstays. But Kathy Gellis, in writing for Texture, says, so there you go, our long national nightmare of not knowing whether any random monkey might be able to sue for copyright infringement has been resolved. We may now go about our lives confident in the knowledge that they cannot, at least not in the Ninth Circuit. Dun, dun, dun. So that happened. We also have a new patent case out of the Supreme Court. So let's talk about that one before we close out the show. So as you were saying before we started the show today, Matt, this is fairly straightforward. It's Oil States Energy Services versus Greens Energy Group is the name of the case, and it had to do with whether or not this administrative means of deciding whether or not a patent is valid was going to stand, and the court it's called inter partes review. It's a procedure before the Patent Trial and Appeal Board. and oil states challenged its validity. The Supreme Court decided it was fine. Can you tell us more about this?
Yeah, so in this, we'll start with the basis of administrative review. And so long ago, back at the Constitution, most if not all decisions were made by the federal judges, who were Article III judges. With the rise of the administrative state, the Article I judges, which are judges who are authorized and execute power under the executive, which means that the executive. So if Donald Trump wanted to remove one of these judges for making the wrong decisions, there's some procedures and there's political things to pay, but he could remove them. And so what the question was is that patent has been ruled in the 1880s or 1890s that patents are private rights. They've been known as private rights for forever, and private rights were not allowed to be adjudicated they were only allowed to be adjudicated in Article III courts. So that's your federal district court, that's your federal Supreme Court. So in the Obama administration came in out of fear, justified and unjustified, of patent trolls and their ability to, because going through patent litigation is so expensive, people were, so say that it costs you $800,000 to go through to patent trial, even if you're going to lose, you would pay $50,000 to someone who filed a patent suit for you just to go away. So there's people going through and just basically picking the pockets of companies. So they said we're going to bring a cheaper, more cost-effective way to invalidate patents, and the IPR has done just that. It's called the death panel of patents, and the number of patents that they kill is like 85%. And you're getting, not only that, you're getting patents that have gone through Article III court. So they've gone through district court and they've been upheld, that are then being held invalid afterwards. So they upheld this system. They said that the private rights does not apply here, and the inter-parties review stands. And as a matter of like practicability, it's not the worst decision. How much an administration is going to care and therefore lend political weight to getting the sort of patent decision that they want is kind of like, well, that doesn't seem like something that an administration is going to have too much wiggle room at. But that's the worry. But I think that constitutionally, I think it was wrong. But it's not the end of the world.
Okay, thank you for the update on that. With that, I think we will move to our concluding material for the show. And in honor of Naruto and the Ninth Circuit finally weighing in on Naruto, we bring you our animal selfie of the week. This one's throwing it back a few years to 2014. It is one of our favorite species of animal selfie, where an animal makes off with a GoPro and makes some good footage. This was an eagle in Arkansas, I believe, who's coming in here for a landing, deciding this GoPro that was filmed. Sorry?
I don't think I've ever seen that many eagles at once.
Yeah, I know. All at once. They were chowing down, apparently, and the GoPro was filming them chowing down. And there's some particularly good talon footage. Look at that right there. Wow. A talon selfie. Me. Yes, exactly. And there's the eagle itself. So it's quite wonderful when an eagle flies off with your GoPro and gives you this kind of footage, and a selfie of itself that PETA would argue is copyrighted and enforceable.
But did the eagle abandon its DNA on the GoPro? That's the real question.
Ooh, very good question. Yes, and probably the DNA of whatever it was munching on there too, as well. Our resource of the week is also throwing it back to a few years ago. I think this is also from 2014 that this was written up. Yes, it was from 2014. And I'm not sure that this product ever came to market, but I wanted to highlight it for our listeners and viewers in light of our discussion today about abandoned DNA. Someone was coming up with a thing called erase and replace, and they were being marketed as a genetics obscuring spray. The product is called Invisible. The two together, erase and replace, and it was by a company called Biogen Futures, and it's a cleaning up product for the DNA that you may otherwise be quote unquote abandoning in the world. Erase is supposed to remove 99.5% of the DNA material on any surface, while replace then obfuscates the remaining 0.5 percentage point through a cloaking mist of arbitrary genetic junk, as this is written up at Vice.com. I do not believe that if you go to the website for this, you can buy this product. I think it was being developed and was reported on in 2014, and I don't believe they've ever come to market with it. I could be wrong, but I wasn't able to find, any sort of evidence that erase and replace were out there, ready to plunk down your hard-earned Bitcoins and obtain. But it's an interesting concept, right? And somebody's definitely thought through the issues that we were discussing earlier in the show. As they say at Vice.com, yeah, I'm paranoid, but am I paranoid enough? You wouldn't want to leave your medical records on the subway just for anyone to read, they point out. So why wouldn't you go through life trying to erase and replace your DNA? I think that would be sort of a sad and cumbersome way to go through life, but somebody is contemplating, or at least was in 2014, giving you the ability to do that. Matt, any thoughts?
The skeptic in me thinks that you're buying really, really expensive bleach because that's going to do the same thing. I don't know that, but I'm guessing.
Yes, they come in these sort of test tube-like containers and have interesting lavender labels with a nice font. So, that's dressing up your bleach nicely. Anyway, what is it? William Gibson is said to have said, the future is here. It's just not evenly distributed. I think this is that kind of an episode. Our tip of the week, could have been its own topic and maybe should have been, and maybe we'll come back to it at some point. But it's a tip at this point, and it has to do with a gentleman named Eric Lundgren. Our tip is if you think you're going to make and sell restore disks for the Windows operating system, and you think you're not going to do 15 months in federal prison for undertaking that task, think again, because that's what happened to Eric Lundgren, who is an e-waste advocate and was quite disturbed and saw an opportunity in the fact that many Windows computers are merely abandoned after a system failure, that people don't just restore the operating system and continue using the computer. Instead, they, cash in, cash out their old computer and get a new one, thereby contributing to the global e-waste problem. Lundgren thought that the free restore disks that Microsoft makes freely available and are only usable if you have a licensed copy of Windows running on the machine in question. He thought it would be a good idea just to make those disks available and solve this problem. He was wrong. Customs agents decided, they saw that he was importing these disks that he had made, I think, in China. And Customs decided this was something they were going to investigate. Microsoft got involved in the process and weighed in and said, not only are they copying They are counterfeiting our restore discs and passing them off as legitimate things that we are distributing, which is not the case. But we have no control as a company over whether those discs are going to be laden with malware, et cetera, et cetera. So Microsoft got involved in the prosecution. And the upshot is that for trying to address this e-waste problem, Eric Lundgren is going to do 15 months in federal prison. So if you were thinking of doing that, it's a bad idea. What do you think, Matt?
Yeah, it seems like the first sale doctrine or something like that should kick in here. I didn't dig too much in the weeds here, but this is how so many of your phones end up going into other countries that are recycled, and a lot of the companies, specifically Apple's recycling program, seems like a great thing, but really it's really just a good way of not having your iPhone 4 or iPhone 5 go on the secondary market. Yeah, it seems like there should be some out for this. That seems crazy. It's a secondary market, especially if it's like an XP or something. But I like I said, I think this would be a good topic for another show too, to dig in a little bit more.
I think so too. But in the meantime, tip of the week: don't make and sell Microsoft restore disks. It's not going to go well for you if this is any indication. And let's see, I think I neglected to mention our second MCLE passphrase for the show. It's going to be death panel of patents, going back to the oil states case that we discussed earlier. Again, that is for purposes of obtaining professional credit if you are a lawyer or other professional who likes to watch or listen to our show for that purpose. And with that...
Oh, hey, Denise.
Matt? Yes.
Sorry, really quick.
Yes.
Somebody had, on this side.
There you are.
Had something to say, but...
Wait, I can't read it. It's too small. Hold on. Show it again.
Somebody's moving it.
Oh, it's Padre?
No, Patrick. There you go.
Yes, animals for selfie rights. Yay! And our little raccoon creature.
And actually, I was at Michael's the other day, and I saw an interesting book that I think you guys would be, interested in. It was
very nice. Supreme Court paper dolls.
I don't know how current it is, but yeah, I don't know.
Yes.
Oh my God.
Well, you were on the resources and stuff, so.
Oh, that's fantastic. Yeah, that would be a great resource and a great topic for discussion, because I'm sure that the members of the United States Supreme Court have not licensed or otherwise agreed to use of their names, images, or likenesses for commercial purposes for that book. But did they have to?
Which school does like the bobbleheads? I think it's like George Mason who does the Supreme Court bobbleheads, which... I got the opportunity to go into a couple of the justice chambers last summer, and they a couple of them had them, which I thought was awesome. I would have a bobblehead of myself if I was on the Supreme Court, no question.
I would have a bobblehead of myself if I were just a person. Who wouldn't have a bobblehead of themselves? It's sort of a delightful alter ego, I would think.
Leo has one.
Yeah, there you go.
Yeah,
absolutely. All right. Well, thank you so much, Victor and Matt, for joining me on this episode of This Week in Law. And thanks so much to our wonderful guest, Camille Fischer, who we let go a bit earlier on. It's been great getting together with all of you and discussing these issues. I've really enjoyed it and have much food for thought as we come out of our discussions today. Hope that we're leaving you with the same. If you'd like to join us for our next episode of This Week in Law, I encourage you to do so. We record every Friday at 11 o'clock Pacific time, 1800 UTC this time of year? No, 1900 UTC. We changed the clocks. So join us if you can live at twit.tv. You can click on Watch Live Now and you'll be off and running with us. But don't worry about it. If that doesn't work out for you, head on over to twit.tv/TWiL, and our whole archive of shows is there for you to enjoy at your leisure and on your device of choice. just for giggles, just to see how good Siri does with this kind of thing. In the car the other day, I asked Siri to play triangulation for me, and within 2 seconds, it had it queued up, and I was listening in the car. So this stuff works pretty well. You can go to our show page, or just see if your personal assistant of choice will just grab the show for you and put it wherever you are, whenever you want it. It worked for me, so that was pretty cool, I thought. What else should we let you know? We should let you know to get in touch with us between the shows. You can email Matt. He is mattc@twit.tv. I am Denise at twit.tv. We'd love to hear from you, your feedback on what we discussed today, your thoughts on people we should invite on the show to discuss further things. Your jokes, your links, your audiobook selections, all of it, send it our way. We love it. And if you want to just incorporate us into your browsing of stuff on the web and let us know things that hit your radar that you think we'd like to know about, we love it when you do that. That's how I pulled up, for example, the story we just discussed about Eric Lundgren. Is one of our listeners sent it my way, I think, on Twitter. So definitely let us know when you see things like that. I'm D Howell on Twitter. Matt is Law Pint there. We have a Facebook page as well for the show. And and of course, there's always good old-fashioned email. So let us know. Keep us posted. We'd love to hear from you. We're so glad that you joined us today. We hope you'll continue to do so on This Week in Law. Until the next time, take care.